In that sense, the Supreme Court shouldn't have even entertained this particular case at all.
At all. Now let me emphasize. A jurisdiction to interpret and to enforce under Article 130 is described as an original jurisdiction. I'm saying that in a situation like this, they don't have original jurisdiction. What they have is a jurisdiction of reference. The subject matter belongs to the High Court. And the same Article 132 makes it clear that in a situation like that, they have only reference jurisdiction. So I don't see, I don't know. That's why I'm emphasizing. And I think that at the heart of all this pretentious discussion going on, there's no true legality involved. It's just politics. That honorable type. All we are doing is the paramountcy of political partisanship. Party partisanship. That is what is controlling this country. If that is not addressed, we are just wasting our time. True law no longer will apply. Where the basis of anything in this country is political, politically driven. That is the menace. I agree with Martin Kwebu's observations along these lines. That is a fundamental matter. Unless it's arrested, this menace, this vice will continue to fester, and constitutionalism will be subverted. Paid lip service to people suffer. In other words, we are not entitled to benefit from the constitutional order put in place for this country. That is the true situation. That's the true evil to be addressed.
So, when you make reference to the fact that clearly the Supreme Court shouldn't have entertained this case at all, in the recent ruling of the 5 who ruled in favor of the plaintiff, they argue that although the High Court had jurisdiction with regard to whether a seat is vacant or not in Parliament, what was before them was purely a question of law regarding the true interpretation of 97(1) G and H, and not factual disputes regarding seat vacation in Parliament.
Sorry to say, that's superficial reasoning.
That's superficial reasoning?
Yes. It is not, but that issue has been addressed by Article 132. Now, where it arises in a matter belonging to another court, the Supreme Court only comes in when an interpretation or enforcement issue arises and is referred to the Supreme Court. That is the only time they can come in. So you don't, take 132 about is it not dealing specifically with that question of law that they are talking of and how it should be brought to the Supreme Court?
Indeed, 132 says where an issue that relates to a matter or question referred to in clause 1 of this article arises in any proceedings in the court other than the Supreme Court, the court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination, and the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court.
Yes, that is the constitutional order. And let me say this, those days that law was, there was fidelity to the law. And even today it's reflected in their judgment, the majority judgment. Jurisdiction is a fundamental matter. So the conditions upon which your jurisdiction arises, if they are not there, you don't have the jurisdiction. And that is it. that this matter is directed to the High Court. However patent the constitutional issue that may arise there, you don't have original jurisdiction, you have jurisdiction of reference. That is it. Is that what they exercised? That's not what they exercised. They purported to exercise original jurisdiction, whereas in this kind of situation, it is only reference jurisdiction. It's quite clear from the same provisions of 130.
So as the Supreme Court has always held consistently, a point of jurisdiction, when taken and successfully upheld, should foreclose any consideration of the merits of any case.
Completely. You don't have jurisdiction, how do you touch the merits? And even in the majority, there is clearly and plenarily stated therein, and I agree with that. Even there's saying as is solidly laid down that as for jurisdiction is so fundamental that even if the parties don't raise it, the court itself suo motu ex debito justitia.
So it sounds like there will be no foundation upon which the merits can stand.
At all. How can you put something of McFarland and USC, Mosi and Bajina? McFarland and USC, I think it's something, but as for Mosi and Bajina, I think it's 1963, volume 1, Ghana Law Report, page 634 or so. Supreme Court. Akupato ASC wrote that unanimous judgment. So, I mean, you don't say that the same issue would have come. The thing is, when do you have jurisdiction over the issue in a matter that is consigned to a lower court? That is it. No, you don't substitute desiderata for, actuality of jurisdiction. Supreme Court.
Well, Justice, I want to make the point and say that to the extent that this matter of jurisdiction is a problem, Justice Abadu says that he finds the decision of the majority as an aberration to the established and accepted judicial position of the Supreme Court, which, with profound respect, he says he hopes in no distant future the resultant usurpation of the constitutional prerogative of the High Court incidental to the majority decision will be reversed. You agree with that?
Well, yes, but the thing is, as I've told you, in the course of time, the Supreme Court was not faithful to the constitutional prescription of stare decisis. So you find Biebel and Sakande going off tangent, entertaining a matter that should have been commenced in the High Court, and then some followed. It's very interesting. If you read that Biebel case, look, the Doche and another justice, that's interesting, eh? They disagreed with the majority decision on the grounds that I'm canvassing. The same grounds. That's very interesting. I think when in human life, it's important to apply realism than other things. That is very significant that happened. The majority decision didn't even discuss, if I remember well, I'm yet to go back to my books. It's 6 years since I've retired, but I think recollecting.
Indeed.
They did not examine Awana Williams and Gredima. They did not examine Yeboah and Mensah and so forth, and try to demonstrate why those decisions should not bind them. That is from a certain time, the Supreme Court, after that, you started sliding down judiciary. I'm telling you. you find that this stare decisis was not observed. You find a panel taking a decision one way. Then another case comes. Either the same panel or a good number of those who decided will take a contrary stand and then back and, I mean, this wasn't happening before. That's why I'm saying something fundamentally has gone wrong. That is what has to be redressed. If we are to get back on track and run this country properly and not politically and myopic. Now,
sir, and you think that politics is a cause of this, that the judiciary continuously being drawn into politics? Because that was a concern by many, that this case may have just overly exposed the judiciary to the politics of it, sir.
Yes, you said?
Sorry, I lost you briefly then. You are talking about the problem that we have, yes, the problem that we are faced with now. And yes, the concern that was raised when this matter started was that this was going to open up the judiciary for the politics of this particular issue. And do you see that as a problem here?
It's a problem. That's a realistic problem. Now I'll demonstrate it. Look even at the empanelment. People has referred to all those. I mean, for what reason will you bring the younger justices to handle such a weighty matter to the exclusion of the seniors? What reason? I mean, this reason, sir. Then they brought in these two others, but I mean, what were they going to do? In fact, even legally, I don't see whatever was left for them to decide on the substance, because in rejecting the application to set aside their injunction, one or their directive, they had ruled that they had jurisdiction. They had already decided that they had jurisdiction. The speaker had no jurisdiction over the matter. It was so. What was left actually for determination? You know? And these same five who ruled that there was jurisdiction, they were still there, and only two came. And the five went the way they went, predictably.
So it was predictable?
Oh, sure. Are you not in this? Don't you follow the horizon of judicial functioning in the Supreme Court? Are you surprised? Tell me, honestly, were you surprised?
The way that the five justices went on the particular case was predictable.
And let me tell you, why wasn't it even, let us even go by pretentious legal theory. They're not the same person who had ruled on the the application to set aside their processes, that they had jurisdiction. And so, I mean, if the same people are to pronounce again on the same matter,
what do you expect?
Okay.
Don't you see
yes, indeed. It was the five who sat on the speaker's application. Yeah. Yes. So the dissenting two were only added on the substantive case.
Yes. And what could two do against five? Look, as I've said some time ago, this question of political poison in the judicial system didn't start today, but it has gotten to, I mean, its peak under this current administration. It has gotten to its peak. And that is the real virus constitutional virus to be redressed. You find the lawyers coming to the studios, they are not coming there really to talk about lawyers, except a few of them. Some like Atuguba, I don't think is politically minded from his presentations. But some just come, their duty is to uphold their party's line. They're not interested in the correct law, but their party position must prevail. That's what's happening. And so, that's the fundamental thing to otherwise this kind of thing will continue under the guise of legality and constitutionalism, under the guise.
What's the danger that we're faced with this situation, as you have so passionately spoken about, if what you have just espoused continues?
What is the way forward?
Yes. In fact, the danger we are confronted with, yes, with the politicization of the judicial process, as you put it there. What is the danger that we are faced with if this continues? That's what I was asking.
Oh, I mean, it will be continuing in the rule of people, rule of politics, not of law. Clearly, that rule of politics, political partisanship. That's what is obtaining. And if it's not arrested, no matter which party comes, we'll continue suffering. That's why I'm so concerned.
Hmm. And continuously...
pardon?
Yes, you were making a point. Sorry. You went silent a bit. Yes, but you can go ahead.
Oh, you have jurisdiction over the matter to ask the questions.
Indeed, I have original jurisdiction on this program. Not a reference jurisdiction. Indeed, so called the
yes, exclusive
jurisdiction. Indeed,
not concurrent.
Not at all.
Not at all. I'm scandalized to see in the reference of some of the majority judgments that on an issue where the Supreme Court
it's unfortunate. We're having this
and the High Court, yes, have concurrent jurisdiction on the matter. The concurrent jurisdiction of kind of concurrence. There's no concurrence there. It says it's exclusive, and I cannot reason by any process to arrive at the fact that when they say something is exclusive, it can also be capable of concurrence with another person. But my mind cannot have.
And the other justification by the majority Justice Siodu wrote that it must be placed on record here and now that there is no provision in the Constitution that when a person perceives that a provision of the Constitution requires the interpretation or the enforcement of this court, or that when it is perceived that a legislation has been made in excess of the powers conferred on Parliament, that person shall first have to institute a suit in the High Court before the High Court could refer the matter to the Supreme Court. Such a stand will be very, in his view, circuitous indeed. Any such condition imposed on Ghanaians is, in his view, with the greatest respect, not sanctioned by the Constitution.
Oh, with all due respect to him, the legal legs is standing on for this kind of denunciation. Is anybody seriously saying that where a cause or matter is within the original jurisdiction of another court and only referential jurisdiction is reserved to the Supreme Court can still purport to have original jurisdiction? And where is concurrence? I mean, the scenario he has even painted doesn't arise. Because you are bound to go there, and then referentially come to the Supreme Court. And let me say this. Politics apart. Long ago, it's not today, Mekankai and the Republic, Asiama and so look, long ago, there's from William Atuguba, if a matter is not ambiguous, any court can apply the Constitution. In that case, interpretation doesn't arise. These days, and from the way things are going, can give the dog a bad name and hang it. Something can be crystal clear. Oh, it's not clear. These are the things. Now let me tell you, this situation has to be arrested seriously for constitutional governance and not political, partisanship functioning. That's not governance. It takes place. One, the mode of appointment of judges suffers from the virus of hepatitis infection. That's even gone to cirrhosis.
The judge has become doctor. Prescribed.
Sir?
Why do you want to establish an independent judiciary and the president is the appointed? And even if you look at the appointment, he specifically has the power to nominate and appoint the Chief Justice, who is the head.
Sir, fortunately, we
want an institution to be independent,
yes.
And the head must be yours. Now, that's nonsense. That's, to use the old party expression, malice aforethought. The pain of the constitutional deterioration in this country. I said there has been massive constitutional deterioration.
Sir, I do appreciate your time and pouring out your heart on this matter.
Is it possible that
Justice William Atuguba, retired Justice of the Supreme Court. Thank you.